So I'm still on the threshold question. I'm conscious of the timing. I spent some of the lunch break trying to reduce the number of references I'm making. So where I'm seeking to support a proposition, I will just take you to one authority and then give you the references to the other, unless a particular point arises. We were looking at the case of SOVAG, that's in the authorities bundle at 26, page 606 and following. This was another multi-party insurer case on the question of whether or not one has to show a sufficient connection. In that case, it was a traffic accident, and the Finnish insured sued the German insurer in Finland and got compensation from the Finnish insurer. So the Finnish insurer, the third party, sued the German insurer for an indemnity or contribution. And I was submitting that it's slightly different from our case here, because we're not looking at a defendant joining in a third party to existing proceedings, but a third party seeking to get at a defendant to existing proceedings. Slightly odd way round. But it's another multiple insurer contribution claim. You can see from the head note on page 606 between G and H what was found. The bit that I rely on.
Could you give me the page again?
Oh, sorry, it's 606, my lord.
606 is just the head note.
Yes, so I'm looking at the head note just to show you what they found.
Oh, right. Okay.
The scope of Article 6.62, it's right in between G and H, included an action brought by a third party in accordance with national law against the defendant in original proceedings and closely linked to those original proceedings. It's the bit that I rely on.
Yeah.
And that in the judgment can be found at page 613. Sorry, 612. Sorry, 613 is right, 45 onwards. And what the ECJ found there is that it's for the national court seized the original claim to ascertain whether such a connection exists. And again, bearing in mind that we're dealing with multi-party insurers case where there's an inherent connection. 47, accordingly, the answer to the question referred is that it must be interpreted, the article must be interpreted to the effect that its scope includes an action brought by a third party in accordance with national law against the defendant in the original proceedings and closely linked to those. And then there's, of course, the proviso, provided that as well. So I say that is another example of the ECJ showing that a close connection is required.
But you said Mr. Turner relied on this case.
He did, I'm saying wrongly.
Right.
Just read properly, it requires a close link.
What it's saying is it's equating the close link to the express exception in 6.2.
Partly, my lord, because you're dealing with multiple insurer party claims again, where the inherent relation was assumed. So the only remaining thing was whether or not there was an abuse in my submission. What's clear when they spell it out is that is what they find. The separate provision is made for the anti-abuse section at the end, provided that. That's the question that they were asked, but in answering that question, they make it clear that there's still a close link required. My own friend also relies on the case of another first instance English decision, which is PHP and tobacco and British American tobacco, a first instance decision of Mr Justice Andrew Baker. I'm going to take this shortly because in my submission the judge, with all due respect, got into a bit of a muddle, and I'll just give you the reference. It's paragraph 46 at page 547 of the bundle. It's my own friend's submission. If needs be, I'll deal with it on reply. But it's not very clear precisely what he's saying. In my submission, that doesn't assist this court in answering the question, and I only rely on the fact that he relies on Barton, which finds there is a sufficiency of connection as supporting his approach. That's at paragraph 48 on page 548, and he doesn't say that Barton was wrongly decided. So, in my submission, not much assistance is to be gained on this question from PHP, tobacco and VAT. Those are my submissions on the need for a sufficiently close connection as part of the threshold jurisdictional test for Article 6.2. I'll address your lordships and your ladyship on whether there was a sufficiently close connection in this case. And I hope to do so quite shortly, as we've canvassed some of the points already in argument this morning. I have. First of all, we accept that it is a contingent claim, and to that extent, we accept that there is a connection. What my submission is that it is not a close connection, and it's certainly not a close enough connection for the purposes of Article 6.2, sufficient to override or derogate from the fundamental principle of Lugano that it should be domicile. It's not a sufficiently close connection to do that. So I do accept, my Lord Justice Phillips this morning suggested that, like all third-party proceedings, or a lot of them, there is a contingent aspect. I say that's not a connection enough, and I'll make that good by looking at the pleadings in the main claim, which you'll find in the core bundle at page 63 is the particulars of the claim. If you don't want to turn it up, that's fine. I can summarise the arguments for you. There was a credit facility, there was a pledge of goods and assignment which was assigned to the bank by GP. There's a purchase contract and a sale contract, and Credit Agricole made a claim for an unpaid invoice as a result. It's literally their claim. It's unpaid invoice claim. Not paid. The defence you'll find at page 74. I should say that the credit facility, that the assignment was governed by English law. There was a separate question of Swiss law in that as well. But all of these matters, your lordships and your ladyship will note, do not have any bearing in their subject matter on my client and the claim against my client. They're all to do with invoices, contracts and assignments to which my client has no knowledge or connection. The defence is at page 74, and several matters are raised in the defence. There are questions of whether the requirements of the credit facility were met. There's a non-admission that they were met. There are questions about the assignment, and there was a non-admission, for example, in particular, about whether butane satisfied the definition of cargo under a particular contract. There was a question about whether the assignment, which was not admitted, was denied on the basis that they were given no notice of it, and they were required to have been given notice of it. All of these questions are questions between the main claim and the main defendant, and do not arise for consideration in the claim between the buyers and UBS. They simply don't arise. It's not the same factual inquiry. It's not the same expert question to the extent there's expertise required. It's not the same law. It's not the same factual matrix. And I won't take you to how other judges have applied their discretion particularly, but it is instructive to see that's what happens in Barton. That's how it's applied there. They are completely separate considerations.
Why do you call it a discretion?
Oh, I'm sorry.
Why is it not just a determination of...
I'm sorry, I don't mean a discretion. You're quite right to correct me, my lord, and I'm grateful for that correction. I mean, it's not a sufficiently close connection at this point in my submissions for the purposes of jurisdiction.
They're not third-party proceedings because to be third-party proceedings, there must be a sufficiently close connection in law.
I am grateful for that correction. Exactly. That's exactly my point. And when you look at the causes of action, the causes of action against my client is a restitutionary claim on the basis of mistake governed by Swiss law. And the key question being is, did GP know of the credit before that the money had come in, before it was sought to be revoked by the buyers? It's literally, those have nothing to do with each other. And one can tell that particularly because Mr Justice Knowles himself directed at the CMC that in June 2021, that the main claim and the Part 20 claim would be separated. And could be separated. So the risk of irreconcilable judgment, one has to assume that if there was an irreconcilable judgment so bad that the convention would apply, the derogation for the convention would apply, that could not have been done. And yet it was done. So my submission is that's as clear as it can be, that there is no connection at the relevant time. And there's no timing point there, that's just one looks at the nature of the main claim and the likely issues on the Part 20 claim. So that's my central submission on why there's no close connection for the purposes of this case.
Well, it would be open to UBS to defend the claim, wouldn't it, on the basis that the payment to UBS was a discharge of the debt?
It would be, my lord, and what I say about that is that all of these actions are taken to minimise the risk of irreconcilable judgments, not to totally eliminate them, and they're taken at a national level to understand how best to proceed as a matter of national law, and obviously Mr Justice Knowles chose to accept that limited risk of irreconcilability of judgments and nevertheless separate out the main claim from the Part 20 claim.
Well, that risk is minimised if the claims are dealt with consecutively, say, in this jurisdiction. It's a whole different ballgame if the claim against UBS is dealt with in Switzerland.
Well, it might be minimised. It's still technically open to my client, and I accepted squarely at the beginning that and to the extent they were a contingent claim, there was a connection. My submission is that it's not a sufficient connection for the purposes of Lugano. So I don't say there's no relation at all whatsoever between them. Indeed, it's hard to think of third-party proceedings, properly so called, where that would be the case, my lord. So if there's going to be a question about closeness of connection, there must be some third-party proceedings which fall into that bucket. Which are they? I say these are preeminently those, where you don't have the same factual inquiry, you don't have the same legal questions, and the court's engaged doing different things.
In this jurisdiction, you can commence, say it used to be, you can commence classic third-party proceedings without leave before a particular stage.
Yes.
And so there was no, as it were, judicial control over whether they were properly brought as third-party proceedings. And so I could see that in that situation, you could definitely say, well, they may be technically formulated as third-party proceedings, but they actually do not qualify as such. But where they are genuinely third-party proceedings and are not brought with the intention of removing the defendant to those proceedings from their proper jurisdiction, then on the face of it, it comes within the...
My lord, you might be right that there is a scale. There's a scale of cases to which this may or may not apply. One could argue that cases that are issued separately but are in fact found that they should be tried together, should they be considered would they be considered third-party proceedings? My question is not when we don't have that situation before us, what third-party proceedings do these cover? And my submission is a lot of third-party proceedings, as your lordship pointed out to me this morning, are likely to be of this contingent nature. Are they all to be excluded from Lugano? Because if most third-party proceedings are those, in my submission, that cannot be right, because what the courts do, what the English courts have done when they look at the question, is look at, well, what's the decision that the English courts are really making as opposed to, for example, the Swiss courts. And there's no overlap. You'll find that phrase repeated in the authorities. No overlap of fact, no overlap of judicial inquiry into legal questions.
Well, are you overstating it? At paragraph 44 of the judgment, core bundle, page 49, the judge accepted Mr Turner's submission that the two claims, the juridical nature, the different juridical nature was irrelevant, as was the fact that different laws were governing the claims. At the very least, each would have to take account of the other in quantum terms. Put that to one side, because I think that's accepted by you. But then, and the two would undoubtedly be part of the same overall factual investigation. And do you say that is plain wrong?
I do say that, or at least it's not a proper analysis of what the underlying causes of action in separate claims require. I mean, lots of things could be said to fall under the same broad inquiry, but properly analysed in the way that one is supposed, in my submission, the way one is supposed to, looking at the causes of action, what facts arise, who the witnesses are going to be, how those are going to get determined by the court. There isn't any overlap here.
So you accept there's contingency, and in that sense, I guess the same thing in different terms, an impact on quantum, but that's not sufficient.
No, in my submission. I mean, there's also the rule against double recovery. It's hard to believe that if there was a quantum finding and some monies were paid back or not, whichever way that's running, that anyone could claim any full amount at a later proceeding. So I don't think the quantum is particularly instructive in this case. There's not any sort of separate quantum, in the third-party proceedings, there's not any separate quantum issue. It's all about the question of whether or not the bank was entitled to deduct GPs from GPs' monies owing to it.
The letter that is relied on as giving notice of assignment isn't the same letter as is relied on as giving the bank notice of the fact that the monies were not due to GP?
No.
Different letters?
They're different letters, Mary, and in fact it's a little bit more complicated than that on the notification.
Okay, well,
there's a series of emails.
There's no overlapping
correspondence
relied upon?
No, my lady. I mean, you could take it, Mr. General, correct if I'm wrong, UBS really has had nothing to do with these exchange of contracts on the butane, these assignments, nothing to do with it, and therefore the only question was about the payment when it was received, what we did with the payment, which was reduce the overdraft, for want of a better word, reduce the amount owing to us by GP. And the only question is if before we got the retraction,
you were on
had GP been, that's the Swiss law requirement. So there is no overlap there in my submission, and that is what the proper thing that the court should be looking at. So whilst there's a contingency, it's not sufficient for it to fall within Article 6.2 at the threshold level of discretion. Now, my second point is what I think has been called the timing point. Still on the threshold question, our submission is, as I just made, there's no connection, but even if there were, it's not in dispute that when the court came to decide the question of jurisdiction, the main claim had settled, such that there were no third-party proceedings and no possibility of irreconcilable judgments, even on the contingent basis whatsoever. And that's not in dispute, obviously. Sorry, the fact that they settled is not in dispute. We say the judge wrongly held that the question has to be looked at the time of issue. That's paragraph 46 of the judgment, if you want to turn it up. And then he actually says the words, at least in the present case. I don't understand what is meant by that, at least in the present case. But nevertheless, we say he's wrong, and the body of case law on Article 6.2 is to the contrary. In the interest of time, I'm just going to take you to the case of Barton again and give you the references for the others. At Barton, it's the authorities bundle at tab 7, page 64, is the relevant part I rely on, and it's paragraph 40. Now, it's right to say, as I ought to, that the facts of Barton... Which
page?
Sorry, it's page 64?
64 is the... okay, yeah. Paragraph 40. Okay.
64 should be Barton, my lord.
Yep, got it.
I'm grateful. I'm squarely going to accept the point, as I must, that the facts of Barton are different in that the permission to issue the Part 20 proceedings was not obtained until after the main proceedings had settled, effectively save the cost. So the chronology is not the same. So I don't rely on Barton as directly analogous for the application of our facts, but rather for the matter of principle and the argument that applied in it. The judge at paragraph 40 is considering the analysis of Mr Justice Phillips in Kinnear, which one can see from the previous page if one needs to. But the point I rely on is not relevant for that, because what the judge says 4 lines down is, further, Phillips J was dealing with a case in which there was a very real likelihood that the claim made by the claimants against the defendants and the claim made by the defendants against the third party would be hotly contested. Certainly, that was the likelihood at the point in time when Phillips J considered the jurisdiction issue. In those circumstances, of course, it was necessary that Phillips J would be astute to avoid there being a possibility of irreconcilable judgments. And I rely on it because he's considering it that at the time he considered the jurisdiction issue. And I say he was entirely right to do so. So for us, it was the time at which Mr Justice Knowles considered the jurisdiction issue. And at that time, there was no main claim at all, there was no hot contest, and there was no possibility of irreconcilable judgments.
I don't understand, really. I understand that you might do that as a matter of practical common sense. But if you're asking the question, is there jurisdiction for these third-party proceedings to fall within Article 6.2 of the Lugano Convention. And surely the only time you can ask that is when they were issued. I mean, jurisdiction doesn't come and go, does it?
Well, I mean,
because if circumstances had changed, which meant that you could legitimately show there was no jurisdiction afterwards, then you would have to acknowledge, in theory, there was jurisdiction when it was issued, it was validly issued, and now I'm saying there's no jurisdiction, so I'm going to apply to stay, strike out, or find some other process by which you could make that a relevant consideration.
Well, in my situation, when one's considering a permission application, that's the time usually when the court has to look at the question of whether permission should
Then the
be granted.
claimant or the applicant is completely at the mercy of subsequent events which may be out of its control, or at least not entirely within its control.
Well, that may be right, my lady, but they're not completely at the mercy because they are actively involved in the settlement of those proceedings.
Yes, but let's say it's an entirely sensible thing to settle 3 months afterwards. I mean, what does the claimant in this situation do? Part 20 claimant do? Must it issue protectively if there are time limits? Must it issue protectively in all possible jurisdictions in case jurisdiction somehow subsequently evaporates in the first port of call?
Well, in my submission, that is the way the English courts approach it as a question of their national. That's what the cases show, that as a matter of our national rules, we've approached it on the question of, well, the judge is looking at the question as it stands now, and the real question is not necessarily certainty for the claimant, but the right of the convention defendant to have its right overruled.
I mean, in this case, is it right that there had been no material change of circumstance between issue and permission application?
Oh no, there'd been the issuing of the permission application.
So in the case we're looking at,
in Barton,
yes,
the proceedings were issued before the claim was settled, so it's not the same chronology.
No.
No,
So we have to be careful how much weight we put onto
I absolutely
the date
agree.
of assessment, if I can call it that.
I completely agree with you,
Yeah.
my lady. I was just sort of pointing out that when so not even for the own case, but when Mr Justice Wynne Williams was looking at how Mr Justice Phillips applied it, it was at the time when he considered the jurisdiction question. I agree. I'm not relying on Barton as being the same as my case. And
Understood.
therefore to be
You
followed.
did make that clear. It's my fault. Thank you.
No. The question is a question of balance, as it always must be, my lady, in situations where you're balancing the certainty for the claimant against the right of a defendant in a convention territory not to have its right to be sued overruled without due reason to do so. And that reason
And
to
so
do
what
so.
would happen if the main forgive me for interrupting, but what would happen if the main proceedings here settled 4 weeks after the judgment on the permission application had been handed down, saying there was a sufficient connection?
Well, I say that what the judges do when they look at this is look at what's happening prospectively as well.
So you wouldn't have a sufficient connection even if you had one on the day of the application if there was a 55% prospect of settlement in 4 weeks' time?
It's an excellently phrased question, my lady. But what I would answer in a slightly more roundabout fashion than you perhaps might like, but is to say that the judge is engaged at the time of looking at that decision and saying what's really going to happen here. And you see that time and again. You see
That's
it in
so
Barton.
uncertain, isn't it?
Well, it is uncertain, but you see the judge applying likelihoods, possibilities. Is there going to be a hot contest? You can see that in the decision in Waterford, where basically there may be trade. The judge looks at the probability of whether there are going to be trademark proceedings in the future and decides that's not very probable, and decides that X is a straw man, so they're probably not going to get sued. These are the type of considerations which the judges have taken into account. There won't be any money in it. I can see your
I mean, there
eyebrows.
is a possibility they were wrong to take those sort of considerations that were really of that ephemeral nature into account. I mean, there has to be certainty as to what is a third-party claim under the Lugano Convention, does there not?
Well, my submission, my lord, is that it has to be balanced, because the main point of the Lugano claim, of the Lugano Convention, is not necessarily certainty, but at its base, at its fundamental base, is the point that a defendant has a right to be sued in the territory in which they're domiciled. That's important.
Nobody doubts that.
So the question is, if certainty has to be balanced against that right, that's where we end up on this knotty question of Article 6.2. And I rely again on the PIF SS case that I handed up this morning, in relation to when the court's looking at questions of expediency, it's well established that the court can take into account future as well as existing claims. And that, the references to that, I apologise, I know that it's loose, but the references to that are paragraph 112.
That's yes.
Where your ladyship found Article 6 looks at the risk of irreconcilable judgment. In doing so, there's no reason why it cannot look ahead on an informed basis, that is, educated guesswork, if I may say so, for the purpose of what is a hypothetical exercise. It can be noted here, PIFSS has taken steps in Switzerland, where Mr Amuzagar is domiciled to preserve limitation. So all these considerations are taken into account, and I rely also at 122 of that judgment, a few pages further on. The relevant authorities either support or do not undermine the judge's analysis. So, for example, as already stated, Calfellis did not address the circumstances rising here, but the court's reasoning makes clear the objective of Article 6 is the avoidance of irreconcilable judgments. Rice-Montage, properly read, does not establish a general principle that the court must only look at the state of play at the time the claims are issued. Rather, matters of national law, including the admissibility of claims under national law against the anchor defendant, I say, ditto third-party proceedings, no principal difference between them, are to be left out of account when considering the operation of the autonomous rules of the Lugano Convention. So I say there clearly is authority supporting the proposition that when the court comes to make that decision, it shouldn't blind itself to what is actually going on in order to properly apply what the Convention requires, which is only to derogate if necessary and if there are third-party proceedings that have to be heard together.
I'm trying to understand how this works. Let's imagine that you have a case where it does meet, the third-party proceedings do meet the sufficient threshold test on issue. So it's within the Lugano Convention. So therefore the claimant can serve on the basis that it's within the Lugano Convention, as in this case. You say that they should have obtained permission, but even if they had to obtain permission, it would have been on the basis it was the Lugano Convention case, if they'd gone for it without notice. Now, if subsequently the main proceedings settled, and you say then the sufficient connection is lost, is jurisdiction then lost ab initio, so that the service was invalid? Or was there jurisdiction under the Lugano Convention, which is then somehow lost, and how does that happen?
My submission
I just don't understand how it works.
My submission is when it comes to the point where the court has to look at the application of its national rules, which I say it must do for the purposes of Article 6.2, it determines whether it's going to, whether that satisfies it at that point. So I would have to accept, my lord, yes, that there would be nothing wrong with service, but nevertheless the court will say, well, I'm entitled to take into account how my national rules work, and as a result, I find that it doesn't fall under Lugano here.
That means that looking at 6.2 itself, it says a person may also be sued as a third party. So you accept in that situation they would have been sued validly as a third party in third party proceedings. So on the face of it, Article 6.2 is entirely satisfied. Proceedings have been served under the Convention. Where do we find in the Convention or any authority the proposition that an action which is founded on Article 6.2 and has been served under the Lugano Convention can then, as it were, be stripped out of the Lugano Convention? Where does it come from?
Well, it comes in, perhaps I understand the hesitancy, if that's the neutral way of putting it, or the reluctance to...
No, it's just a question.
Well,
where does it come from?
It comes from the interrelation between the application of Lugano proper and the national rules at that nexus point in Article 6.2.
Where, forgive me again, where is there any suggestion, either in the Convention or in any case law, that a case that satisfies Article 6.2, so that, which says that a party may be sued, and then they are sued within that article, where do we get any support for proposition that subsequently there in some way is a loss of that jurisdiction?
Well, first of all, I'd say that's exactly what happened in Waterford, Wedgford and David Nagali Limited.
Where did that come from?
Well, I agree that what happened in that case, different to Barton, is that there was a trademark infringement case, and the main claim was determined by summary judgment after the third parties were issued. You can see that it's not easy to follow because it's not doesn't do a chronology. That's chronology is made good in paragraph 3 of that judgment. So on the facts, at least in the chronology, it's the same. And what the learned deputy said at 640 to 641 of the bundle is that where the main proceedings are for whatever reasons no longer active, it will be only in exceptional circumstances that claims can be pursued by way of third-party proceedings. So he found that when he was looking at the question, that absolutely did matter. Absolutely did. And he said, no, when they've settled, when they're gone for whatever reason, there is no longer, what's evaporated is the existence of third-party proceedings. Yes. So in a way, sorry, I'm so sorry, my lord. In a way, what happened is the claimant, in that case, the buyers here, have evaporated their own case. There are no third-party proceedings. So it's all very well to say, you could argue they've relied on Lugano to get us in and then settled it, and then the evil or the mischief, as your lordship did this morning, behind Article 6.2 is still there. So to allow them is not being met.
But
so
I thought you accepted that once the third party who's been joined has actually started participating in the proceedings, they couldn't challenge the jurisdiction.
I do accept that. We haven't participated.
So then it would be a Lugano Convention case, even though there are even though it wouldn't be third party proceedings.
Well, once you've submitted to jurisdiction, that's a different matter, my lord. But where you haven't submitted to jurisdiction, where the question's up for the court and the court then decides, in my submission, where the claimant itself has decided to get rid of the main claim but try to continue with the third-party proceedings, they shouldn't be entitled to do so.
We must move on.
We must, I agree. My junior's note
we
exactly
can't have
that.
different rules, can we, for a claim that is terminated by summary judgment and a claim that is terminated by settlement?
No, I'm not suggesting that, my lord.
Well, you sort of are, because you're saying if you choose to settle it, having obtained jurisdiction for your third-party proceedings, that's your own fault.
Well, if you've gone for summary judgment and won...
No, but the claimant gets summary judgment.
Well, in which case that claim should have been brought in the first place, and Article 6.2 shouldn't apply because the main proceedings were rubbish in the first place, my lord. Not to put too fine a point on it.
Yeah.
But that's where you end up. I'm not suggesting there's maybe different reasoning. I'm not suggesting it's a different rule.
I'm not sure you can say that. I mean, you have summary judgment and there's a perfectly arguable point of law decided against.
Yes, but nevertheless, if you cannot pursue it, there shouldn't be third-party proceedings for a non-pursuable claim in a different jurisdiction. That makes no sense for overriding. I agree, Mel.
Okay, now Mr. Turner's being, if I may...
He's being very patient.
He's being very patient.
I agree.
And he's probably tapping his fingers under the bench.
Yes, and I'm
No tapping.
I've only got one more submission to make about Canada Trust. I'll just try and make that very...
Yes, important to hear about, yes.
Yes. So, first, Canada Trust is not authority for the proposition that the court must look only at the state of play at the time the claims are issued. Still less is it authority for that proposition in relation to Article 6.2. Canada Trust was only looking at a particular aspect of Article 6.1, namely domicile. So our primary position is that's not helpful to the court. I've relied on the PIFSS citations already as to why you can look, when looking at the question, that you can look forward at the time. What happened in Canada Trust was that the anchor defendant, if I can call them that, was domiciled at the time of issue, but then when it came to service, serving the other defendants could not be found. So was he able to move domicile to avoid service, and therefore none of the claims could be anchored there? And the court was balancing very different matters. It wasn't balancing this fundamental derogation principle I have been submitting about all day, nor was it balancing the risk of irreconcilable judgments. it was looking, the mischief that Lord Steyne was looking at in the judgment was that to hold otherwise than the date of service, and no one in this case is contending that date of service is the relevant date, completely irrelevant. The reason the date of service there, if you had it as the operative date, which is the unsuccessful contention, would enable some defendants to evade the service of the process when they became aware of incipient proceedings. And that's him at page 12C of the judgment. So he's looking at a completely different balancing act. And you can see that again in the core bundle at page 49 under 12D. Sorry, authorities 10, 120, 12D. The passage relied on by the judge at core 49 was obviously the idea that the domicile of the defendant would have to be checked upon every time service was attempted is unattractive and conducive to uncertainty. And it's hard to disagree with that, but it doesn't assist this court in analysing the question before it. It is balancing different factors under the convention. It's looking at a different set of facts and a different mischief. And in my submission, it doesn't assist to simply refer to Canada Trust as the answer. As I say, we accept certainty as important, and all other things being equal, it would be desirable that a claimant knows where and if they can sue a defendant. But that cannot be the only relevant consideration. And the balance is different in our case, the factors being different, keeping an eye always, as one must do, on the purpose of the particular articles of the convention. Those are my submissions, put very briefly on Canada Trust, as briefly as I can. I apologise for I shouldn't apologise for their brevity. So discretion, I've got 2 points. The first is that there is a discretion for the National Court on Article 6.2, even if the jurisdiction threshold is met. We don't get here, if you're with me, on threshold, just to work the argument through. But even if you're not, the court still has a discretion to consider, and that's well established by the cases. And I say squarely, it's not a forum non-convenience test. That's my first submission. So it has a discretion. What is the extent of scope?
I'm sorry, but why?
Why?
Is there a discretion?
Yes.
I mean, Lugano is not a treaty where the court has discretion whether to accept jurisdiction.
There is a discretion precisely, again, because of this nexus between the national rules applying to a question of Lugano Convention applicability across Convention territory. So
I mean, there's a big difference between saying to satisfy 6.2, you have to show that these proceedings, in the particular circumstances of this case, are third-party proceedings for the purposes of the autonomous meaning of that phrase, and saying that even once you've decided that they are, you have a discretion to bounce them out. I can't see on what basis.
well, I'll try and help you, my lord. I'm not sure I can. I'll do my best.
Well, show me the authority.
I will. I'll start with Briggs, simply because it's a helpful summary in Briggs Civil Jurisdiction and Judgments, and that's Authorities, tab 31, page 693. And the section we rely on is paragraph 1512, sorry, that's right. It starts
Yes.
Well, that's my first answer to your question, that first paragraph of Briggs summarising the case of Congress and explaining why, when the
He
court...
says it follows from the decision, not that the decision decides it.
Oh, I'll take you to the decision, of course, my lord, but just saying, and I agree, this is the author's thoughts on the subject to that extent, but what he explains is that the question raised by the case before the National Court was whether the third-party claim is an admissible one, and it wasn't a question of the jurisdiction over it. So there's the distinction between those two layers in Article 6.2. So that's where the discretion comes in my submission. We can go and look next at Congress, and that's in the authorities bundle at tab 17, page 296. It's paragraph 17 to 22 of the judgment.
Forgive me, which tab?
Tab 17, my lord.
I would have said that 20 said the reverse of what you're saying.
Well, what 20 is doing is ensuring that however the discretion is applied, it is not applied contrary to the purpose or the function of the convention, my lord.
I mean, it's the proviso, provided that the effectiveness of the convention is not prejudiced, and the leave is not refused on the grounds of domicile. But I mean, I don't see how intellectually it's possible to read in a discretion when the question, I mean, the whole convention is on the basis that the contracting parties have agreed there shall be jurisdiction in certain circumstances. It doesn't say you can see if those circumstances are satisfied and then decide if you want to give jurisdiction. I mean, now I do get it that Briggs gives the impression that they said, if you go back to Briggs,
Yep.
I mean, he actually gives the impression that there is a discretion because in Congress they said the defendant argued the Dutch courts had special jurisdiction and that they were therefore obliged to exercise it, and it appeared that the Dutch court was unwilling to exercise it. The European court, as it would complicate the proceedings, and agreed that the Dutch court had special jurisdiction, but it was not obliged to exercise it. Where's that bit? Because if that's right, and the European court has said that, I'm a bit gobsmacked by it, but I'm, you know, I don't feel we could probably depart from it.
Well, obviously the question starts over the page. The discussion in Congress, it starts at 295.
I mean, I think somebody in their skeletons, I don't know which one of you it was, said there was a confusion between, in the judge's judgment,
It was me.
jurisdiction and discretion.
And here we are. Should we leave it at that, my lord?
Well, I mean, I thought you might be right when I read it.
I still think I am right, my lord, and I'm seeking to...
Well, I'm not saying you're not. I just want to be satisfied that why you're right, if that's the case. Okay, so I'm at paragraph 11. Where should I be?
Paragraph 13, looking at, that's the start of the section before we come on to the paragraphs I referred to 17 to 22. It's the build-up of the argument to that point. So what the court is doing is summarising the different considerations that were put before it about the French court and what should be taken into account as a matter of French national rules and the uniform application of the convention, the simplicity, that versus having to look at national rules of admissibility. And what the court held was that it's not the object of the convention to unify the procedural rules. So that's what I say about certainty to that extent, but to allocate authority to the courts to take cognizance of civil and commercial matters and intra-community relations and to facilitate the enforcement of judicial decisions. So these are all, in my submission, discretionary type considerations, not strict. Are you third-party proceedings in?
Well, sorry, forgive me, isn't this pretty clear what it's saying? Is that when it comes to the application of 6.2, there's no discretion. If 6.2 applies, then the court is obliged to give effect to 6.2. But there is a different question, which is whether or not, as a matter of the lex fori, these are admissible third-party proceedings. So you do have whatever test or discretion there is as to whether or not to allow a claim to be joined as third-party proceedings, as indeed we have in this jurisdiction.
So
but then there is the but if they are third-party proceedings within the lex fori rules, there is no discretion as to then the application of 6.2 if it is. I think that comes out fairly clearly from the Commission's submission at 16 and the answer at 17. There's a clear distinction. Clear distinction should be drawn between jurisdiction and the conditions for admissibility of an action. 6.2 specifies the competent court and does not refer to all the conditions of admissibility proper.
So the way I think that it's been interpreted, if I can put it that way, by Briggs and by the other cases below, is that the fact that you fall within the jurisdictional test for 6.2 doesn't mean it applies with nothing else, if I can put it that way.
You see, my lady wanted us earlier to look at CPR Part 20, and I don't know whether that was outside court or inside the court, but it doesn't really matter.
Now we know.
But now you know. And if we look at CPR Part 20,
yes,
we see that there are all sorts of ways in which a third-party claim can be said to be incompetent, inappropriate, incompetent, not to be tried together, have to be brought separately, whatever. Now, I don't think we need to go and look at all that, actually, at the detail. But isn't that what this is driving at? That there are municipal rules, which will be different in France, Germany and Belgium, which say when the court wants to try cases together and wants procedurally to allow them to be all in one place at the one time or in different stages or by way of different processes. But that's, as he says at 17 in the Congress case, that must not interfere with the, I'm sorry, it's 20, must not interfere of limiting the application of the jurisdiction rules set out by the convention. So you can say this is not a third-party process in our jurisdiction, and we don't want to, even though it might be, I suppose, is that your point, that it's a mixture?
it is, my lord. And also, in this case, that is what happened in this case. When it came before Knowles in the main claim, and the main claim was chuntering on, he said he separated it. It is that, when you look at what the conditions that are required to separate out third-party proceedings, to try them separately, why, that's what I rely on as well in the Part 20. So if they can be tried as separate claims, should Article 6.2 really apply? That's the question I'm asking. That's the question number one. And the answer, in accordance with your lordship's more eloquent discussion of that, is no, it shouldn't. It shouldn't derogate from domicile, where it's not, it can be tried separately as a matter of national English procedural rules. And I say, on the timing point, that's even more the case.
But it does make it rather unsatisfactory, because many claims can be tried separately, but it might be a bit convenient to try them together, or greater or lesser convenience. It might be a question of where the witnesses were and what languages people spoke and what law governed different bits of the claim.
It might well be, my lord, and I agree, and that's why I come back to the bit of Congress which says it should be emphasised it's not the object of the convention to unify procedural rules. The convention is not perfect. It has to accept it's got different players with different rules of the game in each of these convention territories. And they may include all those things you're discussing, my lord. They may not, on proper analysis, in particular facts of the case. But the convention is not trying to harmonise all those, because it can't by the very nature of Article 6.2. So it can't go to the substructure level and harmonise everything and make everything beautiful and pretty and work out from the beginning exactly where everybody is at. That's the thrust of my submission. So what it does is put an initial threshold test in and then say the rest of it is up to you, National Court. And what I say is when you come to the National Court and say, well, what are you doing at the discretionary stage? The court says, well, as a matter of fact, I found that these can be tried differently, so why should the principle of the convention be derogated? It's not undermining the convention, it's supporting it, not to apply Article 6.2.
Well, I completely understand.
Really, that is the heart of my submissions, and I can sense that you don't want me to elaborate too much.
I think it's very difficult, actually.
Yes.
I think
Well, if I could just give you...
I see it, but I think it's pretty unsatisfactory, if you're right, but I see why you say it's right.
I'm grateful. I've been called worse, my lord.
What, unsatisfactory?
Than unsatisfactory, yes.
I wasn't calling you unsatisfactory.
I know.
In fact, I may say so.
Thank you. I won't draw you on that.
Satisfactory submission.
Oh, well, thank you. I shall make sure that appears on my website. My lord, I'll just
I
give you...
don't think it'll do very well in Legal 500.
No. Well,
Satisfactory advocate.
I would take competent. My lord, so I'll just give you the references because I've made the thrust of my submissions, and I say that there's not a single piece of authority in the English courts that supports Mr Turner's submissions. The ones I rely on are Kinnear, that's the Phillips, Mr Justice Phillips decision. For your note, that's the authority, tab 16, pages 281 to 282, under the heading Discretion. I don't think we've got time to read it now, but I rely on it. Waterford, for your note, that's authority 29, tab 29, page 641, and that's point 6 of Deputy Judge's requirements, which we looked at earlier. His own requirements. British Sugar, and that's in the authorities bundle, tab 9 at page 106, under the heading Appropriateness of Part 20 Proceedings.
Page 106.
Yes, ma'am, page 106. And over the page onto page 107, paragraph 50. My learned friend mainly relies on... I think I can say, well, that I've made my submissions on why I say the
But you're going to get a reply, albeit a brief one.
Yes, I've made my submissions on why I say the discretion should apply here. If I might quickly deal with Owusu, that's my final submission. My learned friend heavily relies on the case of Owusu and Jackson, 2005, Queen's Bench Division 801, in the authorities bundle, tab 22, pages 473 to 533. My simple submissions are about this. I won't turn it up, but it concerned Article 2 of the Brussels Convention, and therefore the fundamental principle of domicile, and the issue of whether forum conveniens applied to that, the issue of forum. Article 6.2 is neither mandatory nor fundamental, being a derogation from the fundamental scheme of the Convention. Congress was referred to by the Advocate General in Owusu, and that's why we've included the lesser authority level in that, but that, for your note, that's at tab 22, page 478. But neither the Advocate General nor the court suggested that Congress had been wrongly decided. And those are my submissions on Owusu. They don't take matters any further. So, my lord, I have got my submissions on scope and how it's to be exercised. I've already made. They can't be contrary to the convention. They have to be consistent with the convention. They can't derogate simply because someone is domiciled somewhere else, for example. That would make the derogation a nonsense. But I say it is more in line with the convention to refuse Lugano, to refuse on admissibility grounds Lugano when one looks at the third-party proceedings. I won't make my submissions again. I will repeat them. They're in my skeleton, but they are the same on the admissibility point as they were on the threshold point, or what is relevant, and I've made those already. So those are my submissions on the discretion point.
No, thank you.
Thank you. Yes, Mr.
Knowles, my lady. Just by way of overview, on the first ground, I will largely follow my skeleton argument.
Well, you don't need to read out or follow your skeleton argument because we've read it very carefully. And anyway, speaking for myself, bearing in mind the time we've taken with Ms. John's submissions, I would encourage you to be briefer about about ground 1 than ground 2.
Very well, my lord. Well, on specifically on ground 1, then her big point was lis alibi pendens. That lis alibi pendens is dealt with expressly, or was dealt with expressly in 631.1 and is not dealt with in 633.3. She says, ergo it's not dealing with the same thing. Where that falls down with respect is that there was, to adopt by Lord Justice Phillips' expression, there is a requirement, there certainly was a requirement, until IP completion day under the rules, to self-certify that there was no proceeding ongoing in any other convention court. And that self-certification was dealt with in CPR 6.34, which requires a party seeking to serve out of the jurisdiction without permission to file a Form N510 when filing their claim form, and to serve the N510 with the claim form on service. And one can see N510 in this case if we go to bundle A, the additional bundle, and go to tab 2. And what you see set out over the 4 pages of that form are precisely the considerations which are set out, or were set out, in 633.1 and 2. And so if you go on just over the page, you will see, this is the N510 that's filed in this case, you will see that in proceedings to which 633.1a and 33.1b1 apply, the statement is, and then the statement is made, there's the box is ticked, as it were, and then there's a signature at the end of the form. So the whole lis alibi pendens requirement is actually satisfied at the time of issue. What was always rather odd about 633.1 was that it seemed to suggest that there was an ongoing requirement post-issue that no other court be seized. But of course that's not right, because under the convention and under the regulation, a court is seized when in this country, when the proceedings are issued. In the Netherlands, where service and issue are the other way round, they would be seized when the document is transmitted to the person for service, provided the document was then served. So the season is regulated under the convention. It is not the case in relation to English proceedings, where first you issue and then you serve, that somebody issuing in another court between issue and service here would then disrupt the ability to serve out of the jurisdiction. You would still be able to, the English court would still be the first seized, and it would be the foreign court in those circumstances that would have to stay pending establishment of the English jurisdiction and then decline jurisdiction if the English jurisdiction were established. So this alibi pendens is a non-point. And let's see, my lord, what else there is that I would like to detain the court with in terms of my skeleton.
I mean, there is a point that Ms. John has made, which is, I don't want to start using words again or I'll be in trouble. Anyway, that you need to meet, and that is that the history of the world shows that there was a compartmentalized approach to the drafting of 33.3. Whatever it's now probably got the paragraph number 3.33.
6.33.
6.33. That's the
6.33.3.
yeah, that one. No, 6.33 as a whole.
6.33 as a whole.
Whereas
Yes.
she
Yes, yes.
provides
Yep.
regime 1, regime
Yep.
2, regime 3.
Yes.
And therefore, you cannot suddenly change regime 3 into a thing of general application, which was obviously never intended by the draftsman. What do you say about that?
But what I say about that, my lord, is this, that the points that she makes about the, as it were, the silos that used to apply, break down when one considers what one is dealing with after the IP completion day. After IP completion day, all you are concerned with, so far as Lugano cases are concerned, and indeed so far as Brussels cases are concerned, because your lordship will have well in mind that the changes to 633.3 were made a year before the additional article was plonked into the same statutory instrument.
Yes, I looked at the timing of that.
Yeah.
Yes.
So until
But it all comes into force together.
it does all come into force together, but as one looks at the legislative framework until Regulation 18.3a, I think I've got the number right, is plonked into the thing. If one looks at the legislative framework, it looks as though Brussels and Lugano cases are going to fall in 633.3. As my Lord Justice Phillips said, that the wording obviously covers the position, and one is left with a historical point, which I'm going to come to. The draftsman says, but what are we dealing with post-IP completion day? What we are dealing with is claim forms that have already been issued, because if they haven't already been issued before IP completion day, there's no jurisdiction to issue them afterwards. Lugano and Brussels Convention stops at 2300 on the 31st of December. So I'm only dealing with claim forms which will have their N510s with them, where people have already self-certified that the requirements of 1 and 2 are met. And that being so, there is no harm in them being dealt with in 633.3 and swept up in the wording that is wide enough to cover them now that we've taken out Brussels and Lugano. So that's my answer. Fundamentally, stepping back, what the court is confronted with is a choice in terms of legislative intent, which is, did the legislature set out to do something for which there is no rational explanation, which is my learned friend's case, or did the legislature do something that may not have been strictly necessary, which is my case? Now, obviously, that's tendentiously put, but that is what it boils down to. Now, the other point to cover so far as 633.3 is concerned is the overlap with the gateway. And just to make that perhaps a little bit clearer than it might be, this is the Orexin point. 633.3 and Practice Direction 6, paragraph 3.1.
Just before you go there, aren't you assuming the outcome in making that previous submission? I mean, aren't you really assuming that the meaning of 633.3 as amended is what you want it to mean? Because you say, well, it would obviously have covered Brussels and Lugano on its proper construction.
Yep.
And then when they came to legislate specifically for Brussels, they did that when there was no real need to do it.
I would say out of an abundance of caution in order to ensure alignment with Article 67 of the Withdrawal Treaty, is how I would put it.
Yeah, but I mean, you do assume that it means what you say it means, and she says has to be given a special meaning, which is exactly the same as it was before, namely that it's a very limited application.
Despite the changes, yes.
Yes.
Well, I don't assume that it must mean what I say it means. I say there are some very good reasons why it should mean what I say it means.
Because it's what it says.
Well, I start with what it says, certainly, but I also look in my skeleton. I'm very happy to run through them and take you to the sections in Benyon, at a whole raft of statutory presumptions. Presumption, yes, let's call them statutory presumptions. Presumptions of legislative intent. These are, let me take you to them, my lord, because...
Well, I'd like to look briefly at those.
Yes,
Yes, what's the page in your skeleton?
Well, let's start on page 180 of the bundle, my lord, paragraph 13. So the starting point to the proper approach to the interpretation of statutes and statutory instruments.
Well, we know the text.
You know the text. And then I go on, deal with the text in context. And then I come to the relevant presumptions at paragraph 20, which is on page 183. And those are the presumption against absurdity and the principle that the law should not be subject to casual change.
Yeah.
And the presumption against absurdity is put in a way that I've quoted.
I just thought there might be something in Benyon which helped you with when a statute is changed by a very small change, that you look at the whole thing again, or not? I mean, do you carry the baggage of all the history of the legislation with you in construing it after the amendment, or do you look at the words after the amendment at face value? I mean, there may be nothing in Benyon about that. But
the presumption is that the Parliament doesn't legislate in vain.
that's a different point.
Well, it is and it isn't, my lord. I mean, if Parliament does something, it doesn't do something to produce no effect.
I mean, I get all that, but I'm not sure that answers the question I'm asking.
Well, if you're not sure, my lord, then...
I mean, I understand that presumption, but the one I'm looking for is how you look at... I mean, I'm sure there's buckets of pages in Benyon. I mean, I've spent much of my life with the book, and there's pages about the history of legislation, isn't there? Or have I made that up?
I don't think you have, and one can look at the history of 633.3, and I'm very happy to do that.
No, I don't mean look at it.
No.
I'm assuming in Miss John's favour, because we haven't got endless time, that she's right about what she says, that the history of the legislation would lead one to believe that there was different regimes for different
there was
things, and that therefore 3 wouldn't naturally have been intended to cover everything, because that wasn't what it was for. But when you deleted bits of it, you've got a situation where that's what it apparently said. And the question is there some principle of statutory construction that says you can read the legislation in the light of its legislative history? Because I mean, I have some sort of vague recollection that there is a passionate opinion about that.
I mean, Mr. Tony, I don't want to stop you answering that important question, but you do talk about the principle that the law should not be subject to casual change, and you rely on that heavily.
Yes.
Is that part of your answer?
That would, all these presumptions are part of my answer, but yes. But of course that, in a sense, my lady, can be turned against me.
It can.
Yes.
Absolutely.
Yeah, so I recognise that to be the double-edged sword that it is. I'm handling it very carefully. But the fundamental position of litigants who have issued proceedings under the Lugano or Brussels regime, as it reaches its sunset, it was always and has always been that we could then serve without permission. Now, did the legislature intend to change that law casually? Because that would be, as has been discussed, a very...
That's a very strong point.
Yes.
But and I mean, you know, who knows what the answer is, but the answer may turn on the point I asked you. Because you have to rebut the proposition that a purposive construction here overtakes the natural reading of the because of the history. And because it is so obvious that the history did not intend this wide-ranging effect, and it doesn't look as if the draftsman intended it either, because of the amended legislation.
In which case, Parliament is legislated in a way that makes no sense. That will be the conclusion that the court will have to come to.
Well, has the court ever come to that conclusion? I mean,
Of course not. But
of course not.
Well, but why does it make no sense if Ms Johns is right that actually the alternative is the 20 gateway? That's her answer to it. She said it doesn't makes perfect sense. And on your case, you're absolutely fine. You just go a different route.
the two reasons why that doesn't work, my lady, are first that the nature of the exercise of the jurisdiction through the gateway is different. It involves a judicial discretion, and that's whatever the content of that discretion is, whether it gets as far as forum non conveniens or not. It involves judicial discretion, which is anathema to the Lugano regime.
Right.
So that's the first point.
We've just heard in the Article 6.2 context that it's not.
Well, it is, and I'll come back to that. The position, the other reason that it doesn't work is that that is not what Gateway 20 is about.
Right. Gateway
20 is about domestic statutes such as the Insolvency Act, which may have I'm not an insolvency lawyer, so I'm going to be very careful, try and be very careful as to what I say.
Well, in present company, you should be.
I would be careful. Well, anyway, enough about me. The 20, as distinct from 633.3, deals with domestic statutes which may be allowed in a cross-border situation with judicial oversight to be the subject of permission to serve out of the jurisdiction. So Section 423 of the Insolvency Act, that was the one that was at issue in Orexin.
Yeah.
The whole question in Orexin is Section 423 of the 86 Act within Gateway 20? Historically, Gateway 20, in its original form, had a list of statutes to which it applied, so it was very, very clear. But that was removed at some point in its history, and what was left was where we have a domestic statute, which in a particular sort of cross-border situation is such that it would be sensible for us to grant service out of the jurisdiction because the connecting factors with this country are particularly strong, then we'll grant permission. So that's a particular type of animal. 633.3 deals with something different, and it's a without permission jurisdiction, which is to deal with statutes and things that are introduced by statutes like international conventions. And just to pause there for a moment, Brussels and Lugano were both introduced by statutes, the CJJA in 1982, when Brussels was overtaken by the regulation, and that became the European Communities Act, as did Lugano, because Lugano was entered into by the EU as part of its treaty-granted powers to enter into international treaties on behalf of its members. So they're all statute-based in that sense. But the 633.3 was for statutes and things introduced by statutes which on their face were dealing with jurisdiction in cross-border situations. And Lugano is an absolute paradigm of that, as is Brussels, as is the Hague Convention, 2005. Not sure that my learned friend is right about the residual 1982 Act. That doesn't look to me to fall into quite that category. It's because the point was sprung on me this morning, I simply haven't had time to look at it. But it looks to me that those sections were introduced as part of the Brexit legislation to make some of the retained EU law work.
It's this 15A to E you're talking
That's the one.
about.
Yeah.
Yes, I see.
Yeah. So there's no mistake. 15A to E, I don't think are within the ethos of 633.3.
Right.
But I can't say that for certain because I simply haven't had an opportunity to consider that and research it. But 633.3, its whole raison d'etre, which goes back well before Brussels, we became part of the EU, or the EEC, was to provide for permission-free service where there is a statute or an international convention introduced by statute dealing with international jurisdiction. So actually, in terms of its legislative history, more widely, it precisely deals with things like Brussels and Lugano jurisdiction. It's just that because of the lis pendens rules and things of that sort, it has been regulated distinctly in 633 until now. But there is no longer any need to do it distinctly in 633 because one is only dealing with claim forms that have been issued with the self-certification in Form N510, which covers those bases.
So the three regimes are just done away with.
Well, they are, but there's no need for them to carry on. And obviously, as we're all well aware, one is dealing with an ever-dwindling number of claim forms.
Yeah.
And claims.
Yeah.
My lord and my lords, my lady, I have addressed you on Orexin. And the question really is whether it would assist you if I just point out what I submitted, the sort of key parts of that. I've given you a very long section of Orexin to read. There are some particular passages which hold, in my submission, the key to understanding it.
A very large section
of Orexin. I've referred to a section which is about 5 pages long, and if it would assist your lordship, I would just take you to it and tell you the ones that, parts that are particularly helpful to read. And they start on page 464 of the authorities bundle. And the starting point is in paragraph 35. If I can just run through them. So the second sentence, untrammeled by authority. And you'll remember the question is section 423 of the Insolvency Act within Gateway 20? That's what the court was dealing with. Untrammeled by authority, it seems to me that the natural construction of Gateway, that 3.120a, is that if, as a matter of construction, the enactment in question allows proceedings to be brought against persons not within England and Wales, then the court has power to allow those proceedings to be served abroad. Whether it should exercise that power is a different question. And then dropping down to E, paragraph 37, there were also cases in which the leave of the court was not required. These included by RSC Order 11 Rule 12b, and that was the predecessor, 633.3, and he sets those out. And then continues at 38. It was those rules that the court was called upon to construe in the Harrods case. And then down to G, in that case, Lord Justice Dillon said, but in my judgment, to be within what is now 633.3, an enactment must, if it does not use the precise wording in the rule, at least indicate on its face that it is expressly contemplating proceedings against persons who are not within the jurisdiction of the court, or where the wrongful act, neglect, or default giving rise to the claim did not take place within the jurisdiction. And then jumping forward to page 467 of the bundle, at para 47, so letter E, he concludes, in my judgment, the time has now come to say that the court does have power on Gateway 20 to permit service of a claim under section 423. And at G, the passage that my learned friend has already pointed out to you, his sixth consideration, is that 633.3 contains similar wording to that considered in the Harrods case. And since 633.3 sits alongside Gateway 20, the obvious inference is that Gateway 20 was intended to mean something different and broader, otherwise there would be little point to it. And the difference in the broader is that statutes within Gateway 20 don't, on their face, deal with international jurisdiction, whereas those within 633.3 do. My lord, that was, I'm not not sure I've been of any assistance at all, but that was the additional assistance to that set out of my skeletons I was planning to
Right.
offer.
Good. Good. Round 2.
Round 2. Round 2, did you say, or ground 2?
Okay. Round or round 2?
Well, ground. I wouldn't be so impolite.
So gloves off, Andy. By way of overview on this ground, what I'm planning to cover are 4 topics. The first is the correct understanding of and approach to jurisdiction under Article 6.2. Secondly, the question of timing. Thirdly, the question of appropriate forum and its inapplicability in this context. And fourth, if you require me to, the complaints that some of the points I wish to make are not open to me. So I'll start with understanding and approach.
But the first one is the one that's really important, isn't it?
They're all important, my lord, but I would probably,
well,
yes.
they are and they aren't. Because if you're right about what the exercise is, then it's pretty simple, right? But if you're wrong, and there is a discretion to be exercised, as well as coming within the jurisdiction, then the other questions do arise.
Then it's less simple, my lord. I'm preternaturally attracted to simplicity.
Well, I mean, you heard the debate about discretion, and the point that I think all this comes down to is that because the only words in 6.2 on which you can hang anything at all are third-party proceedings, and third-party proceedings are by their nature jurisdiction-specific.
Yep.
Whilst there is a rule that third-party proceedings must have a close connection with the main claim as a matter of jurisdiction, it's always open to the municipal court to say, under our procedure, it doesn't work to have a trial with this, or it's not necessary to have a trial with this, or Mr. John would say, these proceedings can equally well be tried separately, in which case, as a matter of discretion, they should not be allowed to continue.
Yeah, I follow all of that. I'm going to address all of that.
Good, good.
So the correct understanding in my submission is that for the court to take jurisdiction by virtue of Article 6.2, it is enough that the relevant person, which is here UBS, has been sued as a third party, and that the proceedings were not instituted solely to take the third party out of the jurisdiction of the court, which would otherwise have jurisdiction. Now, could we start, please, with the convention itself, which is in the authorities bundle, tab 1, page 5. This will all be familiar, but by way of refresher, we're in Title 2, which is jurisdiction, and Section 1, general provisions. And in Article 2.1, we have the fundamental rule, which is that subject to the provisions of this convention, persons domiciled in a state bound by the convention shall, whatever their nationality, be sued in the courts of that state. And we have a carve-out in Article 3.1, which is that persons domiciled in the state bound by this convention may be sued in the courts of another state bound by this convention, only by virtue of the rules set out in sections 2 to 7 of this title. And in section 2, we have what's called special jurisdiction. And as you will have seen many times before, Article 5 introduces a series of optional exceptions for certain types of claim. And these, for the most part, are tied up with the location of the substance of that claim and reflect what is sometimes called the principle of proximity. Article 6 has a smaller number of exceptions, which for the most part are tied to the location of related proceedings. And then we have Article 7, which is a special rule regarding jurisdiction in ship limitation proceedings. I'd be very happy to riff on that topic, but it's probably not called for today. Now, Article 6.1, as my Lord Justice Phillips has pointed out, specifies the risk of irreconcilable judgments as a condition for its applicability. One sees that at the foot of page 6. But the requirements for 6.2 are different, and they are just two in number, that the person to be sued is a third party to what the article calls the original proceedings, and that the proceedings were not instituted, quote, solely with the object of removing him from the jurisdiction of the court which would be competent in his case. And I will call this, for ease of reference, the abuse proviso. There are two further points to note. Firstly, although linguistically, at least arguably, and in terms of the Genard report, I believe, these proceedings refers to the original proceedings, the European Court was clear in the case of G, which I'll come to shortly, that it is the third-party proceedings that must not be abusive. Now, on the topic of Genard, and I don't have that particular passage to hand, may I hand up to you a couple of pages from the report. Now, my Lord, I'm delighted to say that this is already been acknowledged electronically by your clerk. So it's
acknowledged as what?
We've sent this to you electronically. Your clerk has acknowledged receipt, so it's definitely on its way. But
lovely, thank you.
If, like me, you can overcome the paper allergy for a moment.
I can't read it very well, and particularly not small print. And what is it?
This is the official journal, or an extract of the official journal, which contains the Genard report, which was the report underlying the original Brussels Convention. So this is, as it were, travaux préparatoires to the Brussels Convention, which obviously underlies the Lugano.
You'll be pleased to hear I have it electronically.
I am very pleased and slightly envious. The point of looking at this is to pick up on my Lord the Master of the Rolls' point this morning regarding what third-party proceedings might mean. And your Lordship made the point, this may just be a lift from English procedure. But of course, at the time the Brussels Convention was drawn up, which was in the late 60s, we had yet to join. So this was a reflection of other countries, the original core 6 member states, procedures. And what one finds, and I'm not going to read it in great detail, but what one finds on these 2 pages, 27 and 28, of the report, are in a sense an explanation of why there is distinct treatment of guarantee claims and other third-party claims. And it is because they are handled, guarantee claims are handled distinctly in some member states' codes of civil procedure. And so other third-party claims are then handled distinctly. And if I could drag you to the second of the 2 pages, so this is page 28, halfway down the left-hand column, there is a section having addressed at some length the position in relation to warranty and guarantee claims. There is a section headed third-party proceedings. While a third-party warranty or guarantee necessarily involves the intervention of an outsider, it seemed preferable to make separate provision for guarantors or warrantors and for other third parties. The simplest definition of third-party proceedings is to be found in Articles 15 and 16 of the Belgian Judicial Code, which provides that, quote, third-party proceedings are those in which a third party is joined as a party to the action.
It's very interesting, yeah.
They are intended either to safeguard the interests of the third party or of one of the parties to the action, or to enable judgment to be entered against a party, or to allow an order to be made for the purpose of giving effect to a guarantee or warranty. The third party's intervention is voluntary where he appears in order to defend his interests. It is not voluntary where the third party is sued in the course of proceedings by one or more of the parties.
The voluntary and involuntary stuff is related to the Belgian Judicial Code in particular.
That's right.
Yes, it's not an issue here.
It's not an issue here. One of the later cases, I think it was Sovag, the question was raised, can a third party itself invoke Article 6.2? Well, that question had been answered a long time before, but held yes. So I said there were two further points to note. The second of those is that the two requirements of Article 6.2 that I have mentioned, which are third party and not an abuse, are of course not the only matters capable of precluding application of Article 6.2, although they are the only ones inherent in that provision. But another matter which would preclude the application of 6.2, for example, would be an exclusive jurisdiction clause in a contract between the defendant and the third party. So if between, if it so happened that between my clients and UBS there had been an exclusive jurisdiction clause in favour of any court other than England and Wales, and we couldn't have invoked 6, indeed even then we couldn't have invoked 6.2. Now, when construing the Lugano Convention provisions, it's obviously right to have regard to the general principles that underpin it. And one of those is the point made in my learned friend's skeleton at 39.2, which is tab 15, page 154 of the core bundle. And that's the point covered by Briggs in the authorities bundle at tab 31, page 688. Which is purposive interpretation, and he explains on that page what is meant by that, and over the page he quotes from a recent European Court judgment, and then says, the last phrase in the passage shows that the correct interpretation of the particular provision is to be found by reference to the scheme and purpose of the regulation as a whole. The approach to interpretation of the Lugano Convention is and will be identical. The judgment didn't say that it was concerned to find the scheme and purpose of the particular article or sub-article which had been of concern to the referring court and in relation to which it had made its reference. It was instead required to make a broader and more comprehensive assessment of the scheme and purpose of the entire instrument. For this reason, attention to the general principles underpinning the Convention is the proper first step in the interpretation of any individual provision. They must be taken as read in all cases in which a question of construction arises for decision. Where they point in different directions, an argument which is well founded by reference to the purpose of the Convention as a whole has the greatest prospect of being found to be correct. And then if we go on to over the page, we see the beginning of 312, which my friends had pointed to, and then over the page at 691 at the top of the page, which is to say the risk of irreconcilable decisions, also discourages a court from adopting an interpretation of an article which would lead to a multiplicity of courts having jurisdiction over a claim or over parts of a claim. Now, he then moves on to consider the principles of legal certainty and predictability, and you'll have seen that mentioned at paragraph 32.4 of my skeleton. But coming back to Briggs on page 691, the principle of legal certainty means that the interpretation adopted should be one which contributes or is not damaging to the idea of legal certainty. There are several aspects to the principle of legal certainty, of which 5 in particular call for mention. We're only going to look at 2. First, legal certainty is the basis for objection to the common law's approach to questions of jurisdiction in general, and to its understanding that judicial discretion is a necessary or desirable element of jurisdictional law in particular. For this reason, arguments which seek to show that a jurisdictional rule, otherwise applicable, should not be applicable because its underlying purpose does not apply to the instant case, will be unprofitable. More generally, a definition of a term such as consumer, which was liable to require the court to decide whether a person deserved that privileged status by reference to a variety of socio-economic factors, is unlikely to be favoured. Second, and rather more justifiably, the principle will tell against a proposed construction of the convention which would have the effect of leaving an intelligent claimant uncertain about where he will be able to sue, or a well-informed defendant unable to predict where he may be liable to be called to account. The existence of autonomous definitions and terms used in the conventions is helpful, but approaches to interpretation, put forward especially in relation to special jurisdiction, may be measured against the requirement that they contribute to the goal of legal certainty. Judgments have been given in favour of interpretations of the special jurisdiction provisions in particular, which would tend to prevent the multiplication or fragmentation of jurisdiction, where claims arise within a single legal relationship. Judgments have also rejected approaches which would require a national court to conduct an investigation of issues of applicable law in order to decide whether it had jurisdiction in the first place. Now, pausing there, certainty is not something to be balanced against the Article 2 right, which is what my learned friend was submitting to you earlier this afternoon. The importance of the Article 2 right is reflected in Article 2 itself and in the narrow construction which is given to the exceptions to Article 2. But once the exception is established, certainty requires that it be seen through. To introduce balance at every stage of the investigation, and certainly after the initiation of proceedings, is to introduce the most massive uncertainty. That is why my learned friend's point about Canada Trust is wrong. If she were right that being sued in your domicile was of such overriding importance, and if she were right that the process is one of balance, then date of service in Canada Trust would have carried the day and not date of issue. But it didn't, and that is because of the importance of certainty. Well, I'm now going to move to look at the EU case law. The EU case law establishes the following 4 propositions, and at this point I'm broadly following paragraph 32.2 of my skeleton. The 4 propositions are these. First, as with the other special jurisdictions, the rational and efficient disposal of proceedings is the rationale for Article 6.2. It is not a requirement that must be satisfied for it to apply. Secondly, if, as a matter of its own rules, the National Court permits third-party proceedings, then that is enough, provided the proceedings do not offend the abuse proviso. And just pausing there and tangentially, not every member state's rules of civil procedure do permit third-party proceedings. German civil code does not, for example. You can give a third-party notice, but all that does is invite someone to come along and attend. You can't get any judgment, as it were, in those proceedings. So I just said, provided the proceedings don't offend the abuse proviso. Now, the first half of that, which is, does the National Court permit third-party proceedings, is a domestic assessment. But it's a domestic assessment. I'll come back to that. It's not an Article 6.2 assessment. The only connection that, third point, the only connection that Article 6.2 requires between the original and the third party proceedings is that it be sufficient for the latter not to offend the abuse proviso. And the fourth point established by the EU case law is that the requirements of national law for the admissibility of third party proceedings must not interfere with the proper functioning of the convention. And the application of forum non conveniens would be such an interference. Now, if I can take you to the cases. The first is Congress Agentur, and I apologise for the correct pronunciation, which is in tab 17 of the authorities bundle at page 286. And these were, in this case, there were original proceedings by a Dutch hotelier against a German travel agency. And the hotelier was claiming damages for a failure to take up rooms that the agency had booked for its customer, which was a German company. And the agency then sought to third party its customer. And the Dutch court refused, and we can see this on page 287 of the bundle, the Dutch at the foot of the page. The Dutch court refused on the ground that the agency and the customer weren't registered in the Netherlands, and that the third party proceedings might hold up the main action, which the claimant shouldn't have to tolerate. And this went up to the Dutch Supreme Court, which requested a preliminary ruling on 3 questions, which are set out in paragraph 6 on page 294. It's worth looking at the questions. Paraphrasing them, they're in the middle of the page there, paraphrasing them, the first question was whether 6.2 could apply, 6.2 being a special jurisdiction, if jurisdiction in the original proceedings was itself founded on another special jurisdiction. Here it was Article 5.1. So can we exercise special jurisdiction 6.2 when the main proceedings are founded on special jurisdiction 5.1? That's the question. Held yes, and we'll come to that in a second. The second was whether the Article 6.2 jurisdiction had to be taken unless the proceedings were abusive. Held no, because domestic requirements might speak against that result. The third question is whether the national court should apply only its own rules. Held no, for reasons we'll come to shortly. Now, the court made its remarks about the rationale for Article 6.2 when it was considering the first of those questions. So really the first of these questions is, does Article 6.2 apply here? Not what must I show for Article 6.2 to apply, but can it apply when my jurisdiction in my main proceedings is founded on 5.1? So the first question starts at in the judgment of the court at the bottom of 294. The first question refers to a case where the competent court pursuant to Article 5.1, which creates an exception to the general principle laid down by Article 2, is seized of an action on a guarantee brought by the defendant against a person domiciled in a contracting state other than that of the court. The plaintiff in the main action and the parties which have submitted observations to the court deduce from the general wording of 6.2 that the rule that a person can be sued in an action on a guarantee before the court seized of the original proceedings does not depend on which provision the jurisdiction of that court was based on. First of all, it should be observed that Article 6.2, which forms part of Section 2 of the Convention entitled Special Jurisdiction, like Article 5.1, an exception to the rule in Article 2, that the courts of the state of the defendant's domicile have jurisdiction. Article 6.2 confers a special jurisdiction, the choice of which depends on the plaintiff's option by reason of the existence, in a specific situation, of a particularly close connection between an action and the court, to which it may be referred with a view to the efficient handling of the proceedings. Then we have the reference to some affair, and the point of the reference to some affair is that exactly the same language is used in some affair to explain Article 5.1. It's all to do with the efficient disposal of proceedings. These are the reasons for the special jurisdictions. Therefore, the Convention permits a single court to take cognizance of the whole dispute. Consequently, the connection between the main action and the action on the guarantee is sufficient to confer jurisdiction on the court dealing with the latter, irrespective of the basis of jurisdiction and the main action. In this respect, the jurisdiction conferred by Article 2 and that referred to by Article 5 are equivalent. Therefore, the reply to the first question should be that where a defendant domiciled, and then gives the answer to the question. So, pausing there, 3 observations. First, the court is saying nothing here about the requirements that must be satisfied for Article 6.2 to be invoked. It's not the question it was addressing. And second, although that is obvious, it can be verified by following up the reference to Sametha, which we've already looked at, and as I've pointed out, uses the very same language in relation to Article 5 as the court then did in relation to Article 6.2 in Congress Argentor. So, what the court set out in this first section is the rationale for 6.2, that the third-party proceedings are a specific situation. Sorry, not that third-party proceedings are a specific situation in which there is a particularly close connection between the action and the court to which it may be referred, with a view to the efficient handling of proceedings. And obviously other such specific situations would be multiple defendants or a counterclaim, which are covered in 6.1 and 6.3 respectively. The court addressed the relationship between domestic law and Article 6.2 in the following section of the judgment, and you'll be pleased to know I'm not going to read it all out to you. But could we start with paragraph 13? So run the 2 questions together. These 2 questions aim to establish whether Article 6.2 of the Convention obliges the court to grant a request for leave to bring an action on a guarantee, provided it wasn't made with abuse in mind, or whether, on the other hand, the court may consider the request in the light of rules of national procedural law. And then you have 17 to 22 over the page, which you've already been referred to, and I won't read out again, looking at the time. Now, that section supports 3 further propositions. The first is that the National Court can take jurisdiction under 6.2 if the third-party proceedings are admissible under the domestic law of the National Court and don't offend the abuse proviso. Second, the application
So
of
it's can or must?
Can, not must. Can.
Oh, I'm sure you're right.
No,
Just checking.
it's a perfectly reasonable question, my lady. Not that you need me to tell you that. The second point is that the application of national procedural rules, this is paragraph 20, should not interfere with the practical effect of the Convention. And third-party proceedings cannot therefore be dismissed expressly or implicitly on the basis that the third party is domiciled in another contracting state. And third, I'm just pausing there, I mean, that in and of itself kills my learned friend's balance point in this, because she's saying, well, you have to balance the domicile against 6.2, but Congress Argentor says precisely the opposite, that one thing you shouldn't be doing is letting the domicile question interfere. Anyway, the third point is that the national procedural rules that are being referred to here are those that relate to third-party proceedings, rather than those relating to international jurisdiction. And that much is plain in my submission from paragraphs 20 to 22. If I can pause there and address paragraph 12 of my learned friend's supplemental skeleton, which is at core 16, page 166. They submit there that the National Court has a discretion to decline to exercise the jurisdiction under 6.2. I make 3 points about that. The first is that I am not suggesting that the English court has no discretion when it comes to the admission of third-party proceedings. Now, the way that it happens to work in this jurisdiction, as my Lord Justice Phillips pointed out, is that if you commence your third-party proceedings before you serve your defence, then you don't need permission. But if otherwise you do, and of course somebody can apply to have your third-party proceedings dismissed if the commencement was not appropriate. So my second point is that discretion in English law is regulated in CPR Part 20, especially at 20.92. And those are the sort of national procedural rules that the European Court had in mind in Kongressagentur. And that reading of the authority is supported by Briggs at paragraph 1512, which is back in tab 31 at page 693. My learned friend has already taken you to this page. It's volume 3, my lord.
Thank you.
So page 693. My learned friend's already taken you to this page, but she didn't take you over the page. And at the top of the following page, Professor Briggs says this: in an English court, the procedural rules in CPR Part 20 will affect the operation of Article 6.2. It appears desirable, however, that national courts be as willing as possible to take jurisdiction over third-party proceedings. In Hagen, a decision by the Dutch courts that the defendant was liable to the claimant would not obviously be conclusive of the liability of the defendant when he makes a later claim in separate proceedings against the third party for an indemnity. The third party may not be prevented from contesting, as against himself, the findings made by a court in proceedings to which he was not party. Pausing there, that's exactly our case. The whole point of the third partying, in this case, in procedural terms, was to ensure that the finding of liability on any finding of liability on the part of my clients would be binding on the third parties, because otherwise they can run all the same points that we have run again. There's no res judicata, there's no issue estoppel that's binding on them. Continuing, there is therefore a risk of irreconcilable verdicts, or at least procedural complications, if the claim against the third party is not heard with the main proceedings, and the court seized of the main proceedings should only be permitted on narrow and compelling grounds to decline to exercise jurisdiction over the third-party claim, if it is otherwise the practical effect of the convention as a means of preventing irreconcilable judgments will be much jeopardized. And third, my third point, is that the court's discretion doesn't therefore extend to some freewheeling application of forum non-conveniens, which I will come back to if time allows. There is a further point, which is that my learned friend's test is apparently that if the two sets of proceedings can be tried separately, then there is an insufficient connection for Article 6.2 purposes. It would have been very easy to state that, but that is not the approach taken in either the Convention or the European cases. The next authority is G, which you've already been taken to. It's core 7, sorry, oh, any of these things. Let me find it. It's tab 11 of the authorities bundle at page 135.
Page 125.
135, my lady.
Thank you.
This case is authority for the proposition that the only connection between the original and third-party proceedings that Article 6.2 requires is that the latter not offend the abuse proviso. My learned friend has explained the facts of the case, so I needn't do that. But it's important to note that the first of the two questions to the court concern the applicability of Section 3 of Title 2. So this is matters relating to insurance contracts.
Page.
for the questions, my lord.
Yes.
Your lordship.
Is it paragraph 13 at page 139?
It's page 144, my lord. It's paragraph 15. 497 of the report, 144 of the bundle.
Mm-hmm.
And what the case was, at least in part about, a major part about, is the intersection between sections 2 and 3 of Title 2. So the second question you can see is the one that we're concerned with. And because this involved insurers, and as I said, that was obviously a concern in the case, that accounts for the formulation of the question, and that also accounts for the formulation of the answer. But there isn't some special substratum of EU case law or law under section 2 of Title 2 that relates only to multi-party insurer claims. That's a fact in the cases, but it's not a sort of discrete body of law. The approach is the same. And there is nothing in the case law to suggest, in the cases, to suggest that the court was saying implicitly or explicitly that there would be a different approach in a non-multi-insurer case. So the court starts addressing that question on page 146. And it explains that under Article 6.2, perhaps the easiest thing at this point, given the time, is if I just ask you, please, to read from 25 to 36, please.
Yeah.
So obviously the particular paragraph that I rely on, but not just plucking it out of the judgment, it does sit properly in it. It follows that Article 6.2 of the Brussels Convention doesn't require the existence of any connection other than that which is sufficient to establish that the choice of forum does not amount to an abuse. Now,
I thought it was Article 8.2 in the Brussels.
it is under the regulation.
6.2.
6.2 in the Brussels Convention, 8.2 in the regulation.
Yeah, thank you.
Add to, my lord.
I find these paragraphs quite difficult to unwind because Ms. Johns does make the fair point that it is in the context. We have to read paragraph 33 in the context that it follows that Article 6.2 in this context does not require the existence of. You say not, though those words aren't there and it's a general broad statement. Then why does it follow? It says it follows that. And that follows, amongst other things, on paragraph 31, which is the inherent nature of the relation between the main action, is the insured liable, and then the question of who's on cover, which is, you know, the nature and the facts in issue potentially in the main proceedings and the indemnity coverage proceedings are very different, but there is an inherent relation.
My lord, my lady, as I read it, it's perhaps easiest to read 30 and 31 together
Right.
as belonging together, and 32 and 33 as belonging together.
Well, that's how you would have to read it.
Well, I'm trying to make sense of the language that the court has used in the particular circumstances without the court having said there is a particular approach which applies and applies only in cases of multi-party insurer claims.
Because it's for the National Court to, looking at paragraph 32, they do follow on. I get 30 and 31 are both dealing with inherent relation. So to inherent, paragraph 30, it's the existence of a connection in the two sets is inherent because there's an inherent relation between the main action and the proceedings between insurers, forgive me. And then it's for the National Court seized of the original claim to verify the existence of such a connection, i.e. such a connection means an inherent relation.
No, such a connection.
Right, in the sense that it must... Right, well, I'm wasting time. I'll have to look at it myself. But you say 30, it's 30 and 31, and then 32 and 33.
I think, I mean, they do all belong together, but they're definite sense units. One starts with the middle of 30. The existence, as the Commission and Advocate General have emphasised, the existence of the connection between the two sets of proceedings is inherent in the very concept of third-party proceedings. Would your lady give me a moment, Your Ladyship?
Do you understand?
No.
Okay. Do you understand? Yes. Don't worry.
I mean, it seems that the two sides in this case are becoming imperceptibly drawn together, really, because everybody accepts there's a discretion of some kind. The discretion seems to be one for the municipal court based on its municipal law. The jurisdictional question is just abuse and the need for a connection. I mean, I think even this doesn't really gainsay the need for a close connection between the main action and the, as a matter of jurisdiction, between the main action and the third-party proceedings of some kind. I mean, you couldn't just call them third-party proceedings when they were unconnected.
No.
And that's all to do with risk of inconsistent judgments. So, what's the difference between you? I mean, the only substantive difference between you now is that Ms. John says, yes, but the court, if the court concludes that they could be tried separately, no doubt, brackets, without injustice, it should allow them to be.
My Lord, that's an entirely fair observation. What I would say is this, that the difference between us is partly a question of approach and partly a question of emphasis. Because your Lordship is quite right that if one approaches it from my point of view and says the connection that is required is that the taking of third-party proceedings must not be an abuse, using the term in the European
We
sense.
understand.
Then you still need to look for a connection, obviously. Whereas her approach is you have to establish the connection before you consider abuse. Because you'll remember she stood up on this point and said, I don't suggest there's any abuse here. And the strength of the connection that is sought, if the flip side of it is abuse, is going to be less strong than it is if you approach it in the Mr. Aldous way and say, well, you've got to have a risk of irreconcilable judgments and you've got to have...
Well, she says the whole thing is about people being sued in their domicile and this is a derogation and blah, blah.
Well, so it is.
And so it is, but I mean, she says that's what it's all about and the purpose of construction has to be given full effect. I mean, I think bearing in mind the time and the length of the argument, this is a case where the court is going to have to go away and put a large wet towel over its collective head to look at the judgments. I mean, one of the things we haven't done, which would have been useful to me, is to read these European decisions in order, really complete, because even the very early ones, I mean, they have to be read as being very early ones, because as we know, the court has changed its approach. But you do need to do that to really understand, because I don't think the European court has quite the same intellectual mindset that we have about the difference between jurisdiction and discretion.
No, that's exactly right, Robert. I mean, where to come back to the generality of your lordship's question, what I suggest the proper approach is for the English court to say, or put it this way, it would be, if one ignores the fact that one's dealing with issue before service of defence, one imagined that this was an application for third-party proceedings. Obviously, one takes into account the same things. Then the court would be perfectly entitled to look at the connection between the main proceedings and the putative third-party proceedings, and say, actually, for a whole series of case management reasons that have nothing to do with, and what you've got to be careful about is not introducing forum non-convenience by the back door, but for a whole series of case management reasons that have nothing to do with the international dimension of this, there isn't a sufficient connection for me to allow the third-party proceedings as third-party proceedings. In this case, you're going to have to go off and issue a separate claim form.
Well, because that's what slightly happened here. So it makes the timing point very important.
Well, it does, but that isn't
what slightly
quite
happened is the judge said, as a matter of case management, I think these cases should be tried separately.
Well, can I help you with that, my lord?
That was actually because of the timing issue.
That was the timing issue.
He was very worried about delaying the main proceedings, which was very simple.
Exactly.
For this complicated jurisdictional
Thank you,
appeal.
Mary. That's absolutely right. Mr Justice Knowles, who was also the judge on the CMC, was very worried about splitting up the two cases, because two sets of proceedings, because he precisely saw the issue estoppel point that I've already raised, that you would effectively have a position where the third parties would not be bound by findings of fact made in the main proceedings. But what tipped the balance was that the commercial court at that time simply couldn't, weirdly, could accommodate the trial of the whole action sooner than it could accommodate UBS's jurisdiction charge. So the trial of the whole action was going to be held up by a year.
Weird. That's the way it goes. Yeah.
Well,
it is weird.
yeah, but I wouldn't want your lordship to have the impression that Mr Justice Knowles took the approach that these cases can readily be tried apart.
No, but I mean, your point on timing is the point that I put repeatedly to Ms John, and I think we know what you say about it, which is that you have to have certainty of jurisdiction, and once you've issued the proceedings are on foot. That's right. And which bit of that didn't you understand? They're on foot and they can't disappear. Yep. That's your point. That's my Schrodinger's cat point. Yeah. I'm not going to mention Schrodinger's cat. Yeah, we'll leave Schrodinger's cat out of this. But yeah. So that's that. Your fourth and fifth point, third and fourth point are forum non-conveniens, which we, I think, all get probably in this context. Yeah, I mean, the bull point on forum non-conveniens is it has and can have no role to play in a Lugano Convention context. Well, I mean that
we don't argue.
You don't argue.
I said at the beginning, we squarely say it's not.
No, exactly. And then, as for what's not open to you, I look to my left and right because, for my part, I think it's very important that we decide this case correctly, as opposed to on the basis of concession. I don't know whether.
Thank you.
I think that's what we're saying. So we don't need to press against that.
Would your lordship give me a moment just to look through my notes and see
Yes, of course.
what else I feel I have to say?
Can't talk to your junior.
It's, God, so 310. It's 310. We're just doing that on the paper. It's 310. It's 310 still alive, or if we're just doing that on the papers.
Yes, I mean, as for 310, if it arises, I would have thought we can deal with 310 on the skeletons, can't we?
With while my learned friend is getting his bearings, with one exception, subject, I understand that entirely. We've handed up a case which was Lady Justice Nicola Davis sat on, which is Petroleum,
Yes.
which I was going to make submissions on, which is obviously only came down last week.
Yeah.
So we A, wanted to bring it to the court's attention, and B, those won't be in our skeletons. Perhaps, if insofar as we want to make submissions on it, we
You
can
could
provide you
send in one page within 24 hours.
send you a postcard, effectively, my
Send us
lord.
a
Yes, we
postcard.
can. We'll send you a postcard about Petroleum, and I'd be happy, subject to my learned friend, to deal with it in that
Yeah.
way.
Good.
Well, my lord, I'll sit down.
Thank you.
I think that just leaves my reply, which, given how brief my learned friend was, I'll attempt to be obviously even briefer. The Gennard report was interesting, and I'm grateful for my learned friend, as I'm sure the court is, for finding it. But it's important to understand what it does. It just explains for a particular national procedural scheme, in that case Belgium, what that was looking at the time of the
But
Brussels.
it does rebut the point I made when I was actually thinking of one of the Hague Conventions, looking at all the travail on that, and the British were incredibly influential historically, but in this particular case they weren't.
We weren't, and I'm grateful to my learned friend for pulling it out, but just for my submissions to put in its context, it helps with that aspect. It doesn't obviously purport to define third-party proceedings, it just says this is how Belgium does it. In fact, over the page it says Germany, as my learned friend says, doesn't have those. So that is helpful for context and taking the correct approach, but nothing else in my submission. I understand what my learned friend says about, I understand I wasn't there at the CMC for obvious reasons, but Mr Justice Knowles, what it's worth, couldn't really remember when we were at the jurisdiction, and my learned friend gave evidence as to what the issues were. The transcript, the judgment isn't very helpful, it's in the bundle if you want to see it, but I don't think any of that matters, my lords, because the only thing that matters is a matter of fact, he did separate it, and for me that's the point. And if you can separate it, that shouldn't be considered. If one's looking at it, if I made an application because I said, no, if I, in a different case, I had been joined in, and I said, no, this should all proceed separately under 20.9, and the judge had in mind whatever considerations, expediency of getting on with the main claim, all submissions that are usually made, applying the provisions of Rule 20.9 on such an application, he would still nevertheless have separated it out. And that's how it would have come before him.
So what do you say should have happened at that point with those proceedings?
Which ones? The current ones, the ones between Credit Agricole and the buyers?
No, the third-party proceedings. Should he at that point have said, well, these are no longer Article 6 proceedings, and so I sit aside service?
I would say it's open to him to do that, my lord, but there was no one there to ask him because I wasn't submitting to the jurisdiction. So, in a sense, the example I'm giving you is if it was my application and I brought it, obviously hypothetically, under Part 20.9, that's what I would have been inviting him to do, and it would follow on. It can't work on the Lugano point, but yes, to be consistent, if it would be open to him, the court's own motion to do that, but no one was there to say that, so the point didn't arise, and I had my jurisdiction application extant, which came on to be decided later. The only other point to make...
And we've got the transcript of that hearing, haven't we, at tab 7 of the supplementary bundle?
We do, and the judgment, but the judgment isn't particularly long or helpful, otherwise we would have been taken to that, I have no doubt, by one or other of us, in pursuance of our own prey, as it were. But the only other points, my learned friend relied early on in these submissions on the form N510. Insofar as it matters, that N510 is a bit of an oddity on it being the case after issue is a bit strange, because it provides, in that my learned friend rightly, when he issued, ticked the box saying 3.331 applies for Lugano, and signed a statement of truth, and that's important, a statement of truth. But what happened is that, in fact, as soon as midnight struck, he could no longer rely on 6.331, even on his own case for Lugano, because that had vanished. So what is the status of that form N510? Unclear. My slight problem with it, in my submission, is when there was an application made to extend the claim service of the claim form made to Mrs Justice Cockrell without notice, in which the position was maintained, namely that they were still able to serve out under Lugano, and reference was made to form N10 through the sealed claim form being supplied, and therefore before Mrs Justice Cockrell, the knotty issue wasn't brought to her attention that in fact it wasn't 331 anymore, 6.331 anymore, because that was gone. It was something else. So it's not really for my learned friend to pray 510 in aid as an answer to the learned judge's questions about the application notices at the additional bundle tab 1 reference. But to answer the question about, well, it doesn't matter because you've got 510, which allows the judges to, which says that we've got lis alibi pendens. That status of that form is completely unclear following IP completion day, because it remains incorrect, especially on an application to extend a claim form. So it doesn't help, it just remains in a sort of procedural mechanical cul-de-sac held in suspension, because it doesn't, that statement of truth is no longer right. They're not able to serve out under 6.331 anymore.
I think, isn't the point that, by definition, any such claim would have been issued before IP completion date?
Yes, that is the point. He took it forward to say that we've ticked the right box about lis alibi pendent, and we've got.
So all the cases we're talking about now.
Yes, that is the point.
Will have been self-certified by definition.
That is the point he made. But the problem is that form is a nullity from the point of at midnight. What is that? In fact, that statement of truth is no longer correct after midnight, because it doesn't remain the case.
Well, so, I think the point is that does that matter? Because insofar as your point is, well, you no longer have 33.1.1. Point is, you don't need it because they will already have done it by definition.
That was the point he used it for. He was making. But in my submission, what my submission is, in short, that it can't really be relied on for that, because it goes into a strange procedural cul-de-sac, because it remains true and not true at the same time. There's a statement of truth saying he's able to serve out under 6.331, and he cannot. And indeed, that is not his position now. He says he can serve out under 6.333, so the functionality of that very form is thrown into question. It serves no purpose, and it doesn't assist the court. It's incorrect, in fact. If you looked at it today and asked my own friend, are you purporting to serve out under 6.331, he would say no. So my point is, it doesn't answer it because it's literally, in effect, nullified at the stroke of midnight. And those are, on the stroke of midnight, it's a dramatic way of ending, but that's my final submission in reply.
Just, I know I don't have
on the
it,
new
but
cases, yes.
just on the sufficiency of connection point, the judge in his judgment below, at paragraph 44, says expressly that he thought, I would say, having had even more argument about connection, thought there was a sufficiency of connection. That's in the core bundle at page 49.
Yes.
Just for completeness.
Can I just ask, you mentioned Petalia. Is there anything in Petalia that's new? Does Petalia take things forward?
Oh, that's a pop quiz. I had submissions.
There is, I mean...
I'm so sorry. Do you mind if I
No,
refer to mine?
I said you said you wanted to do it in writing, and that's fine.
I would prefer not to answer your...
Fine.
I'm so sorry,
No, I think my lord indicated you could put in...
Yes,
They'll be very
Fine.
short, and I don't think it takes matters very much further than ideal shopping. but it is a case of idle shopping, but it is an additional claim which should be brought.
Well, we should look at it, and you can give us a page of text on both sides. But can we have it by tomorrow night?
Yes, of course.
If possible, please. Very good. Well, thank you all both for your excellent argument, and we will take time to consider our judgments and let you have them in the usual way, and when we hand them down, please use them only for the proper purposes of agreeing in order and costs, and if anything has to be argued about, which I'm sure won't happen, that can be done in writing, and if you argue about how the writing should be presented, we will direct how it shall be presented in writing. And, very good. Thank you both.
All right.